Greetings and salutations, and welcome to the next lecture in Business Law series, where we're now going to examine the sources of Australian business law. So, let's go. Sources of law. We have two sources of law. We have the Parliament. This is also called the legislature, and that's where they make statutes. And we have the other area of law where law is determined, which is the courts. So the courts are judge-made law, and we sometimes call these cases. And what we will see is we're going to examine parliamentary or statutory law as the first example. Okay, here, right in front of me, is a copy of a statute, which is blocking me, but it's wonderful. Now here we have the corporations law. We have the Corporations Law, and it says the Corporations Act 2001, Commonwealth, and then says Section 124, subsection 1.
Section 124.
124. So what we have is the name of the statute, the date that the statute was made, which is 2001, the Parliament that made it, in a shortened form, which says that it's the Commonwealth or Federal Parliament. We have the section and we have the subsection number. So, coming back to our next issue, here we are. What have we got? Here's another example, and this is what the section itself would say. We have Section 18 of the Australian Consumer Law, which says a person shall not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive. We will be looking at this in more detail when we look at advertising and some marketing issues. It's a very prominent section, one you should know. Okay, what have we got? Coming back to legislation, how do we get legislation from being an idea through to being an act of Parliament? This slide says, how is legislation born? And as I said, an idea occurs to someone that the law is unfair. It is unfair that marketers mislead and deceive the public with their advertisements and don't tell the truth. Leads to a drafting of legislation because an action group has lobbied Parliament, and then support grows, that we have the drafting process.
So the draft, is it an act or a bill?
It's a bill. It's a bill during drafting, and it's only when the bill is presented at Parliament that we have the whole process really starting. So when it's a bill, it is in the draft form. It is not legislation. It is not the law. It is only a draft for people to discuss and debate. This goes through a parliamentary process where it goes through 3 reading speeches. It gets put to committees, and specialist people look at it and report back, giving comments on what's correct or not with the law. So the debates and the committee sessions are separate. When it's got through the 3rd reading speech and gone to royal assent, the Act actually becomes law, and from the date of royal assent, it is valid and part of our daily law system. Okay, so what other things have we got? The second source of law that I mentioned before is the decisions of judges. Now, this is applied by judges applying the law in decisions or fact situations that come to them. The issue is we have a system called a doctrine of precedent that already determines a few things. 1, that we have a hierarchy of courts. 2, that certain judges bind certain other judges. And the other issue is judges can be overruled by legislation. Generally, judges don't overrule legislation. They only apply the law. They don't normally overrule it. There is an exception we'll look at in a minute. Generally, the part of a court decision that is binding is ratio de sedende. You're in the picture. And the other one is obiter dictum. Here we have a hypothetical dispute which shows that at a trial division it's the applicant and in the federal court and the respondent, and we have a trial in a statute in a state court which says plaintiff and defendant. So poor Mr. Smith was not having a good day. Here we go. If you've got to ever find a case, the way that you find it is by using the citation. The citation for the case, and this is how you write up a case for your assignment and for whenever you cite a case in anything that you do legally, you'll put the name of the cases with the appellant first, followed by the respondent if it's an appeal case, the year in which it was reported, the volume of the reports, and then appeal cases, APPCAS, is actually the name of the reports in which it's reported. These are a volume of reports that all lawyers can go to find this case, because there is only one case that starts at page 337. And you all gradually get to know these sorts of references. Okay, with our issue of precedent and the court system, we have our High Court. On this slide I've shown you the current members of the High Court. We have 7 judges in total. They can sit in 3 different formats as 3, 5 or 7 judges, and all of these descriptions are described as the full court. A single judge is only used for preliminary matters and chamber matters, which is debates about procedure. The High Court sitting, the other picture shows the number of barristers that were involved in the Australian National Wage case, in which all the barristers at the bench going back, they're all barristers till about the second last line in the photo. Shows how many people were involved and how many interest groups were involved in the National Wage case, which was heard by the High Court in its original jurisdiction because it was disputes between states. Okay, with precedent, as I said, you need to have a hierarchy of courts. What we see here on this is our current court hierarchy. There are 2 systems, which if you look at them, there is one that says state. If you follow that angle down, you'll see that the High Court is part of the state appeal system, and you will see that it starts with Magistrates Court going to the Supreme Court, Magistrates Court going to the County Court, then there is an appeal to the Court of Appeal, and finally an appeal to the High Court. What this tells us is that the Magistrates Court is bound by decisions of the Court of Appeal, County Court and Supreme Court and the High Court. What it actually shows then on the other side in the green column is the appeals in the federal system, because we have a federal system of judiciary starting with the Federal Magistrates Court, the Federal Court single judges and the full Federal Court. There are appeals from the magistrates to the Federal Court, and from the Federal Court to the full Court, and then ultimately to the High Court. What is shown on the pink side of this is that everything below the yellow line, and if you continue it across the green, everyone at the bottom 2 boxes are single judges. Everybody, when it says Court of Appeal, full Federal Court and High Court, are several judges. You do not normally appeal, except in the county and the Supreme Court, from magistrates' matters to a single judge. You always appeal to 3 or more.
You can, with the High Court sitting in its original jurisdiction, may sit as a single judge, and then you could appeal beyond that.
Yes, you could.
Yeah.
You could. But most times with the High Court, because their original jurisdiction is things like disputes with the states, that's going to be already a full court. You'll have 3 or 5, and whenever it's a constitutional matter, there's
7.
always going to be the 7 there, because they all like hogging the limelight. Now, one other word that we should probably go through a quick definition of is the meaning of the word common law. Common law has 3 definitions. Law other than equity, and equity is a separate category of law. So law other than equity means things like contracts, tort, statute law, all those. That is as an alternative to equity. The second meaning is case law, which we've been discussing. Most lawyers will say common law and mean case law, meaning that they are decisions of judges. And that's what we say when, well, the common law says. It's what the judges say. The third one is that we will describe our system in Australia as a common law legal system. This means that we derive our laws originally from Britain, and that these laws follow the English concept when compared to the European concept of statutory enactment of the laws, rather codification of the laws, rather than just a system with judges and the rest. Okay, so let's continue on. Back to our doctrine of precedent for cases. This is helpful to know which ones will bind what and who binds where. And it is the superior courts bind lower courts. Remember the slide previously that dealt with the courts and showed the courts of appeal and the High Court. They're all superior courts to the Magistrates Court and the County Court.
Just a sort of editing, what we might do is then, if we could have the previous slide didn't sort of come back in,
Yep,
and say,
that'd be good
here's
idea.
an example.
Yeah. That'd be good. As in, here's an example and put it down here so you could point.
Something like that, yeah.
That'd be nice. Okay, so next. Dun dun dun. Oh.
You've just broken it. That you've just ripped the Monash blue screen. And while Paul's away, the cat shall play.
and Andrew is going to. So, how do these two...
No, you just fix what your mistakes. It's my turn now. How do these two sources interact and work? Well, the judges, who are these handsome young men, well, of moderate age, in the right-hand box there, and these judges apply what Parliament has made. In other words, judges apply statute. Now, judges, there's a difference in approach by individual judges, and it's based upon theories of what we call statutory interpretation. And one's called a literal approach, one's called a purpose or a purposive approach. And these two theories are based upon how judges perceive their roles. Some judges may perceive their roles as merely applying what the law has been, what Parliament has given them, and this is basically adopting a very strict interpretation of the separation of powers doctrine, or judges may believe that they need to refine the Act of Parliament slightly. This is called more of a purpose approach. And this is why you don't ever do your video work with children, animals and Paul.
I was wondering why there was a clip here.
So, judges will apply laws, but judges will also fill a gap. So, here's an example. In that section 18 misleading deceptive conduct slide we saw earlier, the word mislead and deceive is not defined, or those words, I should say, are not defined. That means the judges in a court case have to then interpret or define those two words. Now, you may think that that leaves judges with a lot of discretion. The answer is yes. So, Parliament may actually intend or have intended that judges should have a lot of discretion. In other pieces of legislation like taxation legislation, you'll have a lot of terms that are defined because Parliament don't want to give judges a lot of discretion. So, Parliament make laws, if you like, make statute. Judges then interpret those statutes, and judges come to a decision. That decision becomes binding precedent, and that means that we have the two sources interacting. Now, judges will make a decision, so they may interpret a particular term in a statute. Parliament doesn't like that interpretation, so Parliament can simply enact another piece of legislation called an amendment that will then change the term. or redefine the term to avoid what the judges have decided. Here's an example, copyright, and my friend Paul, fresh from his
Blue screen
instruction.
disasters. Yes, my blue screen disasters.
Does he have to pay for that? The answer is
Yes, yeah. Take it out of my research funds. Ha! Now, the Copyright Act, this is one of the quickest legislative changes that has ever occurred. It took basically 6 weeks. The Federal Court in 1983 decided that there was no copyright in a computer program because it didn't fit within the definition of a literary work, and that was required for copyright protection. Within 6 weeks of the decision coming down and before the appeal to the High Court could be decided, the Copyright Amendment Act of 1984 was brought through, which basically said, and the amendment is still valid, it says that a literary work includes a computer program, both the source code and object code. So that was an example of where the courts overruled the law, even though the High Court came down in favour of it being a literary work independently of the change in statute. The decision didn't really need to be made by the Court of Appeal. Okay, so in summary, what we have is two sources of law, being statute or parliament, statutes made by Parliament, and we have the courts with judge-made law, determinations in cases. We have a federal system in Australia, which means that there is a state system of courts and parliaments.
Didn't explain that.
And there's a federal system of courts and parliaments.
We're going to go back and do that.
Yeah, I've got to do that on that court system.
That's okay. Well, that's another amendment.
And we forgot about that, with the parliaments. Okay, the other issue is that courts can overrule Parliament only if it's outside the jurisdiction of the Parliament to make the decision, such as the Queensland Parliament making a law that affects the citizens of Victoria. Now, it hasn't happened yet, although there have been lots of threats by Joh Bjelke-Petersen and a few other ratbags. Okay, now, Parliament can override a judge's decision by changing the statute, but it has to go through the process of how parliamentary law is born or how legislation is born. Thank you. It has been entertaining.
And thankfully, it's still in one piece.